It's time to stop some deception today. All constitutional rights invoked, none waived. It's been a long time. We shouldn't have left you. And we back. Okay. We sorry we kept you. Alright. All constitutional rights invoked, none waived to my beautiful and brave. Okay, we gonna get into this. This is about to be terrible. Okay? So we want to start off by letting you guys know what this is. Okay, this is a motion for reconsideration for a motion for default judgment and request for jurisdictional discovery. Now I'm going to read this, and I don't want to bore you guys. I just really don't, but I have to read through this for the people that understand this type of stuff. They're going to really get what I'm trying to say. So it's important that I explain this so that everyone understands. So we're going to get right into it immediately. We're going to get right into it. Okay. All right, now comes Plaintiff Mark McCormick, living man with all constitutional rights invoked, now waived. Plaintiff asserts the supremacy clause of the United States Constitution, and specifically the First Amendment, to petition this government for redress of grievances. The plaintiff also invokes the 14th Amendment of due process and equal protection of law. Okay, we're going to get into the memorandum. Okay, before I get into the memorandum, let me explain to y'all what's going on here with this situation. Okay, for those who know the law, when you are sued in a lawsuit and you fail to respond, there's something in the state of Arizona that's called an application for default. So you have to file an application for default and an affidavit, okay? Now, once you do that, you're placing the court on notice to go ahead and enter the party into default, whoever didn't respond to the actual complaint. So that's what happened. That's what happened in the case. That's what happened. You know, a couple of the parties didn't respond. So I'm going to break this down real quick here. The plaintiff wants to simplify his argument herein and precisely point to the miscarriage of rights guaranteed to him under the United States Constitution, which takes authority over everything in the matter due to the fact that he is the injured party. Okay, so I'm the injured party. So, you know, I'm the one who brought this action completely. So the primary focus is supposed to be on me and my rights and what I'm doing. Okay, because I brought the action. It's kind of like a person, you know, when they call the police. If you call the police and you summons the police for help, you know, they're going to come to the person who summons them for help because you actually picked the phone up and you summons them for help. So they're primarily paying a lot more attention to what you're saying because you're the one who picked up the phone and summons them for the help. And this is the same thing. So when you initiate a lawsuit in court, you know, the plaintiff is the one that is the one that has to have the light considered most in the plaintiff's favor because he's summoning the government for help for redress of his grievance. Okay, so in this case, that's what was done under the First Amendment to the Constitution of the United States of America. All right, so we're going to just get it right into it. Let me just give you guys a summary of what happened. So basically, you know, we had two defendants that went into default. They didn't answer back. You know, they didn't get a lawyer. They didn't plead. They didn't answer back. So subsequently, what ended up happening is they went into default. All right. So when they went into default, all that was pre-planned because what they did was when they were served, they tampered with the postal with the post guy. I can't get the name. With the postman, with the mailman, they tampered with the mailman and somehow convinced the mailman not to require them to sign the certified mail return receipt. Now everybody who's watching this video know that if you get something in certified mail and the the mailman requires for you to sign for it, it's going to be something that's urgent. It could be a lawsuit. It could be something urgent. You know, a lot of times it's dealing with legal or a legal matter, but it's urgent. So what they did, so what Florida Lottery did was they convinced the mailman not to require them to sign the return receipt and just give them the parcel that he was delivering. So whoever that postman is, probably more than likely by now, he probably doesn't have a job, or he's going to not have a job, because it's easy to trace down who was actually on that route and working that particular day, because he actually still delivered the mail to them, and he allowed them not to sign for it, and he returned the return receipt anyways. He returned it to me, and it was unsigned. Okay, so whoever had him do that, they knew in their minds, well, if he get the card back and it's not signed, then that court won't have jurisdiction, which means that it was premeditated and it was intentional. So it was premeditated and it was intentional. Okay, so when they sent that card back to me, it wasn't signed. So I just held on to it because I had an alternate way of proving that they were served, which I know can hold up in court because it's from a source that's reliable, that the court can depend on, which is the United States Postal Service's tracking system. Okay, so we reported all this stuff to the United States Postal Inspectors before the courts made their decision on the motion for default judgment. And we did that as a way to cover our ass, because we knew that it was all premeditated, and we knew that it was going to lead to somebody being in big trouble, because we just sat back. We didn't say nothing. That's why we haven't uploaded any videos. We haven't did none of that. We sat back and we were quiet as a motherfucking mouse. And so now we're coming back out, and now we're showing you what they went on ahead and did. Okay, so we're going to show you how they got the court officials in trouble, because whoever at the Florida Lottery had that done, they had this commissioner named Cynthia Gialketsis at the Arizona Superior Court. They had her to go ahead and issue a ruling that was basically helping them. So basically she knew that they didn't sign this card, and it was all set up, okay, just to abuse me. So let me get right into it. It says Exhibit 30A1 through Exhibit 30A2 is attached here too. And what that exhibit is it's Cynthia L. Gialketsis' order filed 11/22/2023 denying the plaintiff's motion for default judgment, which was obstruction of justice, because it was premeditated because of what they did with the Florida Lottery's return receipt. In California, they did the same thing with California Lottery's return receipt. They just didn't send it back at all. And if you go back to the videos, we provide the tracking numbers for those, and those can be tracked. And they also tampered with the tracking numbers to those. Okay, they tampered with the tracking numbers to those, but whoever was doing the tampering, they didn't really cover their ass too good, because there was other tracking numbers to indicate that these parties were still adequately served. So that's what I said, the divine will trick you. The divine will trick you when you're doing criminal activity. You have to keep doing it, and it only takes but one time for you to get caught, for you to get your head knocked off. And this is what's happening right now. Their head is being knocked off. So let's go down to this. The plaintiff followed all the steps that he was obligated and had a right to obtain default against both Florida Lottery and California Lottery. Okay, so again, we pointed out to several different things that are problematic in this situation. Okay, number two, let's get right into it. The plaintiff filed his motion for default judgment on October 16, 2023, and it was mailed to Cynthia L. Gialketsis on October 17, 2023 via certified mail tracking number 95890710527008427772322 and received by her on October 19, 2023 according to the United States Postal Tracking Number. The motion was not decided on until November 21st, 2023, which is proof that it was premeditated what they were doing, okay? Because she had no good cause or no reason to wait. She had no reason to wait, okay? She waited because they already had instructions and told what to do. So all these people are criminals. So she waited until November 21st, 2023, which is not a usual time frame that a motion for default judgment is decided on at the Arizona Superior Court. The plaintiff was forced to wait more than 30 days to receive a decision on the motion. It could be inferred that the commissioner, Cynthia L. Gialketsis, intentionally obstructed the justice owed to the plaintiff because she specifically waited for a ruling from Michael Gordon, which she was not obligated to do and had nothing to do with the fact that the defaulted parties failed to answer and defend. Cynthia L. Gialketsis creatively waited for Michael Gordon's ruling and issued an order titled and attached herein as Exhibit 30A1-30A2, which she used Michael Gordon's order to support her erroneous and illegal ruling in this Exhibit 30A1-30A2. Moving right along. In the order, she says the court has concerns that the court lacks personal jurisdiction over the defendants in which plaintiff seeks a default judgment based on the reasoning and finding of Judge Michael Gordon in his ruling dated November 8th, 2023. Now let's pause there. So why are you making a ruling in your order that's talking about what Michael Gordon is doing? Okay, if that was the case, then Michael Gordon would have ruled on the default motion from the begin with. He would have ruled on the situation, but he deferred it to you. It's because y'all had this set up already. Okay, all right, and the court didn't lack. The court was not trying to determine if it lacked personal jurisdiction over the defaulted parties because they're defaulted. They did not show up. They did not answer or contest. They did not answer or contest at all. They never contested the court's jurisdiction. So, she was untruthful in that order. Okay, now let's go to the quotation. Let's go over here. Cynthia did this together with Michael Gordon in an ex parte fashion to give the defaulted defendants another bite at the apple at the cost of the plaintiff. The order issued by Michael Gordon, which is attached here too as Exhibit GB 304, should have had no bearing on the decision rendered in the order issued by Mrs. Gialketsis. Gialketsis also stated in the order, the court also has concerns regarding the fact that the plaintiff has filed numerous lawsuits and they have been found to be frivolous and implausible. See footnote 2 of Judge Michael Gordon's ruling dated November 8, 2023. This is problematic due to the fact that no lawsuit that was filed and served to defendants in any federal court or state court was ever found to be frivolous. The case referred to by Michael Gordon and Gialketsis was a case filed in Arizona District Court that was before Judge Douglas Leroy Reyes, who was found to be protecting a crime syndicate and also who blocked the plaintiff from exercising the federal system's national personal jurisdiction in an effort to foreclose justice against defendants named in that lawsuit who are also members of a crime syndicate. Okay, so these people all work together, and I'm sure Douglas Leroy Reyes know what Gialketsis did and know what Michael Gordon was going to do. And what they're trying to do is they're trying to work together to create an appearance that a legal proceeding is going on because going on fairly, because Judge Douglas Leroy Reyes know he fucked up and he violated that Constitution. So that's why this case is in this court, but they thought they had it all premeditated and they were being watched and they fell right for the cheese in the rat trap. Okay? Now, no defendants were served in that action. No summons was issued in that action, and it was foreclosed because federal judge Douglas Leroy Reyes basically summed it up to, "I don't believe you," which he was without the adequate authority to do so because the plaintiff's Seventh Amendment constitutional right was triggered in that action and ignored in violation of 18 U.S.C. 241 and 18 U.S.C. 242 of federal law. Cynthia's entire order need to be overturned completely due to ex parte communication and fraud upon the court in violation of both federal law and the United States Constitution under color of state law. Crazy. It is a fact that defendants Florida Lottery and California Lottery both received the plaintiff's complaint and summons, and they failed to answer and defend. The order issued by Gialketsis contradicts itself because it stands to use Michael Gordon's order to support its finding of fact and law, but Gordon also granted plaintiff leave to amend the complaint to cure jurisdictional defects while refusing to address Carroll and Company's argument of inadequate service of process, which Gialketsis could not have used to support any attack on plaintiff's service of process on defaulted parties. Okay, on the defaulted parties. All right, so if Gialketsis would have tried to rely on the certified mail by Florida not being signed and the certified mail card for California not being received by plaintiff due to the crime syndicate holding it back, the preponderance of the evidence standard could have concluded that ex parte communication between the defaulted parties and the court took place in an effort to organize obstruction of justice in the matter herein. The evidence proves the defaulted parties received the summons and complaint according to the evidence provided by plaintiff Mark McCormick in his motion for default package. The evidence is from a source that the court can depend on, which is the United States Postal Service tracking system. The defaulted parties also had an obligation to sign the certified mail return receipts and failed to do so, and in an effort to preclude jurisdiction, while they failed at doing so because the United States Postal System's tracking specifically advises that they were delivered the summons and who it was left with and at what time. Such alternate proof of delivery thwarted their plan to disrupt the court's jurisdiction. Their act can be considered intentional due to the fact that they had an obligation to sign the cards and send them back, and they didn't, which is considered an intentional act against this court's machinery, which in this act alone would give the court personal jurisdiction over them anyways for obstruction of the court's machinery. Okay, the certified mail is regarded as the court's machinery for service of process on out-of-state defendants. Gialketsis also stated that the court is rejecting the default packet and will direct the plaintiff to submit a new packet if and when the above issues are rectified. Now let's pause for a minute. This was her attempt to give those defaulted parties a second bite at the apple. What she wanted me to do was serve them a complaint again. Okay, amend this complaint and serve it again, and then give them time to, answer all over again because they don't like what was cited in the motion for default judgment. Okay, they got knocked upside their head and they ain't like that, so they said, "Oh, we got to get out of this. We got to get out of this." But they had it premeditated. They already had it premeditated to see what I was going to ask for and then try to give them a second bite of the apple. But they caught, and it's not going to happen. I'm not serving them again. I'm not serving Florida Lottery. I'm not serving California Lottery. They got to pay up, and that judgment that was issued. That order that was issued by Gialketsis, that motherfucker getting overturned like a fish in hot ass grease. What the fuck they thought they was doing? Moving right along. Such statement is evidence of organized obstruction of justice and fraud committed upon the court's machinery, which automatically gives the court personal jurisdiction over the defaulted parties for committing such act in concert with the court and in violation of the United States Constitution and federal laws. Plaintiff spoke with Beth at Gialketsis court, and she advised that the ruling would be done on the 20th of November. And when the 20th came, she called out, according to a female whose name we think was Amanda, but we're going to just call her Jane Doe because we're not really sure about the name. And she spoke with Plaintiff November 21st, 2023, and advised that she will be issuing the order in regards to the default on November 22nd, 2023, once she meets with Gialketsis. Okay, so these people were playing and taking orders from the cabal. Okay, we ain't stupid. We know what y'all was doing. We was watching you. We was watching you, and we shut up real quiet to let y'all think, oh yeah, they're tired. But we not tired. Wait till you get to the end of this video. Patti LaBelle gonna tell you that we ain't tired. Okay, number 12. Plaintiff Mark McCormick wants the court to be aware of the fact that both Gordon and Gialketsis' actions are components of organized crime and obstruction of justice because they got together and strategically operated in partnership in a conjoining and stretched time frame to conjure and commit acts that purportedly connects to their erroneous rulings that support one another to short the plaintiff justice. Cause undue burden and delay while trying to create the appearance of sound proceedings, like the plaintiff is some sort of feeble-minded person who wouldn't detect the elementary abusive tactics. Okay. 13. Gialketsis' order is without governing law to support it and must be reconsidered, vacated, and the default judgment must be granted in accordance with the law, whether Gordon or Gialketsis feels disdained about it or not. Gordon's order specifically states each have been dismissed based on jurisdictional defects, but will be dismissed without prejudice and with leave to amend to address the jurisdictional defects found. Gialketsis was obligated to conclude that the amendment was not futile, that amendment was not futile, and only jurisdictional defects were decided and not the merits of the complaint. The merits of the complaint was not decided. Therefore, she could not have relied on the allegations contained in the complaint to deny the plaintiff's motion for default judgment against the defaulted parties that did not contest the court's jurisdiction. Gialketsis illegally acted as counsel creatively for the defaulted parties, so it can be inferred with the preponderance of the evidence that she had ex parte communication with them. Therefore, her order must also be vacated on those grounds as well. And she will be getting a complaint filed against her and Michael Gordon with the Judicial Committee like Allison did. Number 14. Plaintiff points to new evidence obtained November 5th, 2023 that supports his allegations in all lawsuits relating to the lottery claims. Plaintiff Mark McCormick was not in possession of such evidence and supporting facts before November 5th, 2023. The facts contained in the following exhibit changes the entire landscape of all the rulings made in the case with respect to the Multi-State Lottery Association and all other defendants, and most importantly, it turned Gialketsis' order belly up. This evidence was immediately sent to all defendants' counsel as soon as it was within the plaintiff's possession. This rebuttals Gialketsis' findings of implausible. Okay? Exhibit Menorah is 17 pages attached hereto. It's a lawsuit won and filed in the Iowa District Court for Polk County on January 3rd, 2017. Certain facts contained in this lawsuit supports plaintiff Mark McCormick's allegations, okay? Starting from the top. Number 1, in this evidence discovered November 5th, 2023, and distributed to the defendants and their counsel on or around November 7th, 2023, plaintiff Mark McCormick discovered that it is a fact that a lottery ticket is considered an express or implied contract, which the court can take notice that a contract existed unilaterally between all defendants, and plaintiff Mark McCormick is considered a third-party beneficiary of the contract between Muscle, which is the Multi-State Lottery Association, and their member lottery departments, which the court can rely on to determine personal jurisdiction. Number 2, the plaintiff would like the court to take notice of all the underlined and starred averments in Exhibit Menorah and use any facts contained therein to support the plaintiff's position in the case herein. Number 3, this exhibit contains information that shows a pattern of related activity as alleged in the case herein, and that the activity alleged to be committed in this exhibit resulted in payment to class members of a class action lawsuit and the conviction of an employee of the Multi-State Lottery Association. Plaintiff requests for jurisdictional discovery. Number 4, the plaintiff wants the court to be aware of the fact that in this exhibit it is alleged that the member states, develop lottery departments that are autonomous from state government, which would render any notice of claim requirement irrelevant because the lottery department will not be considered a public entity. Therefore, plaintiff Mark McCormick requests jurisdictional discovery to find information related to the defendant Arizona Lotteries Lottery Department and their contract with Defendant Multi-State Lottery Association that provides an exact name of that lottery department. Also, to determine if Arizona Lotteries intrastate games still use RNGs provided by Muscle. Exhibit GB 304, 6 pages attached here too, is Michael Gordon's order. Filed 11/17/2023, which was abusively used to support Gialketsis' denial of plaintiff's default judgment, which was denied on 11/22/2023. Plaintiff explains the problem with Michael Gordon's order issue and why Gialketsis cannot rely on its finding to support the denial of the default judgment against the defaulted parties. Number 1, plaintiff wants to inform the court for purposes of clarity that Judge Gordon failed to understand that the brunt of the effects was felt in the state of Arizona, and the plaintiff was and remains a resident of the state of Arizona during all times such acts were committed. So the state of Arizona has a duty to provide the plaintiff with a constitutional right to have his case heard in his home state because he felt the effects of the foreign act that was committed in his state, which is the forum state, and the act was directed on the state of Arizona because they stole their tax money, they usurped state tax money from the state of Arizona, and they usurped millions and billions and billions of dollars from me. So number 2, the plaintiff wants the court to be aware of the fact that traditional concepts like purposeful availment and foreseeability do not always work well when applied to intentional conduct outside a state that causes injury within a state. However, courts have tried to tie these terms to such situations. For example, courts have stated that within the rubric of purposeful availment, the Supreme Court of the United States has allowed the exercise of jurisdiction over a defendant whose only contact with the forum state is the purposeful direction of a foreign act having effect in the forum state. Similarly, courts have connected this situation with foreseeability and activity by defendant need not physically take place in the forum state. See Core-Vent Corporate versus Noble Industries, AB, 11 F3D 1482, 1485, 9th Circuit 1993, quoting Hastings versus Grass Valley Medical Reimbursement Funds, LTD 784 F.2D 1392, 1397. 9th Circuit 1986. See also Dole Food Company versus Watts, 303 F.3D 1104, 1111, 9th Circuit 2002. These citations support the fact that the court erroneously removed Muscle from the cause of action and erroneously used the wrong standard to make the rulings of JMS and others and Muscle. Also see Burger King 471 U.S. at 471 to 476. The Supreme Court's analysis of personal jurisdiction is not always consistent, although one might say the court is adapting the criteria to different situations, example, contracts and torts. The focus is supposed to be on the plaintiff and the effects he suffered for the acts that was purposefully directed at the state of Arizona to usurp state taxes from the state of Arizona and usurp prizes both interstate and intrastate from plaintiff Mark McCormick. The court's interpretations are intentionally erroneous and fraudulent. Exhibit 30B1 through Exhibit 30B2 is 2 pages, as Michael Gordon's order filed 10/04/2023, and which was abusive which was abusively used to support Gialketsis' future pre-planned denial of plaintiff's default judgment. Now, we're going to take a look at all these exhibits that I'm referring to in here, but I'm just reading this pleading for everybody, for the lawyers who's watching. They can, see how dirty these people are, okay? All right, so this order that I'm talking about now, this exhibit, which was the order from Michael Gordon, was the order that he came out with after I filed my application for default against Florida and against California on September 27th, and he said the commissioner is going to be hearing this, hearing the motion, hearing the default situation. So he pushed it over to her, and he knew he would push it over to her because he knew that they was going to have her be on that fuck shit. You see what I'm saying? And then she was going to kick it back to him, and it's all to abuse the time clock. You see what I'm saying? It's all to discourage me and abuse the time clock. But I ain't tired and I ain't abused. I'ma abuse them, okay? So plaintiff explained the problem with Michael Gordon's order issue and why Gialketsis was used to act as the fraudster who would interpret the defaulted party's advance thwart of service of process, which is considered an extrinsic fraud upon the court, and it gives the court personal jurisdiction over these hoes automatically. Okay, so you got personal jurisdiction over you automatically just by doing that, thinking you was smart. You thought you was doing something. You wouldn't do nothing but dig yourself in a hole deeper. Okay, you can tell by the way Michael Gordon and Cynthia Gialketsis played hot potato with plaintiff's decisions on his motion for default judgment that it was all pre-planned. And I'm going to pause there. It was pre-planned because in her order, she turned around and passed it back to him and said, okay, well, I'm referring this back to Michael Gordon. He's going to decide the next default motion for default judgment. It ain't going to be no next motion for default judgment because you're going to reconsider that and your fucking order is going to get vacated and this default judgment is going to get issued. Rather, I don't give a fuck who don't like it. Okay? All right, moving right along. In this exhibit attached here too, Michael Gordon ordered that Gialketsis would hear the default motion as a result of the filing of plaintiff's application and affidavit for default filed September 27, 2023. Gialketsis turned around and passed the hot potato back to Gordon in Exhibit G304, 6 pages in her order. She basically said that, okay, he's going to hear it when it comes around the next time. No, ain't going to be no next time. The plaintiff is not reserving the California Lottery or the Florida Lottery to give them a second bite at the apple illegally. The plaintiff moved this court to vacate Gialketsis' order and issue the default judgment against the defaulted parties within 7 to 10 business days due to their abuse of the court's process collectively. Okay, and the conclusion is, for the reasons stated herein, the plaintiff moves the court to reconsider the motion for default judgment filed 10/16/2023 and vacate Gialketsis' fraudulent order and issue the default judgment against the defaulting parties. The plaintiff also moved for jurisdictional discovery as well. So that's it. Okay, and we filed this on November 25th. And it's still not on the docket. They didn't put it on the docket yet because I'm pretty sure they don't like, the fact that I was able to read them and read them back to one another. So we're going to move right along in the next clip. Now, these are the exhibits that we turned into the court attached to that motion that you just heard me read. Okay, but we opened it up with a general affidavit. We started it with a general affidavit, and it says there is nothing in the record that supports that the defaulted parties, Florida Lottery and California Lottery, have not been served. Gialketsis' order issued November 22nd, 2023 is believed to be a premeditated fraudulent move in concert with the defaulted parties through ex parte communications. Number 2, I suffer no legal disabilities and have personal knowledge of the facts set forth below. Okay. All right. So this first exhibit is the order that was issued by Gialketsis. But before we read in that, we're going to go and look at the earlier order that was issued by Michael Gordon. So I'm going to flip through this real quick, so just bear with me. I don't want to get you guys dizzy, so just bear with me because we're going to put this all the way together so you guys can see. Okay. Now, this was the order that Michael Gordon issued on October 3rd. Okay, as a result of me entering my application for default against the defaulting parties on September 27th. So he basically said, before the court is plaintiff's September 27th e-file application and affidavit for default against Joe's service station above caption, but it was against all of them on that date. It was against all of these defaulting parties, Florida Lottery and California Lottery too. He just didn't want to mention them. For whatever reason, he decided not to mention them, and that's proof that he decided not to mention them in this. He just decided to mention Joe's service station because he knew that Joe's service station was going to come in before those 10 days was up and still get a chance to file a motion to dismiss. But he didn't say nothing about the Florida Lottery or the California Lottery. He said nothing at all about them. And this is, again, more proof on a preponderance of evidence standard that they colluded to do this. So basically, in this order, he said he's not deciding this, okay? He said it is ordered that no action will be taken by this division on the above referenced documents. The parties are advised that commissioners handle Rule 55B default judgment proceedings and that the default proceeding in this matter are to be heard by Commissioner Cynthia Gialketsis. It is further ordered that all documents necessary to support the entry of default judgment must be e-filed. Pursuant to the Maricopa County e-filing guidelines, section 2.09, attorneys shall electronically file all documents required to request a default judgment, such as application for entry of default, motion for entry of default judgment, some certain affidavits, and we did all that. I'm not going to read that. So basically, this was his order saying he ain't deciding it, right? So he passed it to Gialketsis, okay? And then Gialketsis, she turns around and she issues this order after I filed the motion for default. She issued this order here. And she says the court is in receipt of the default packet submitted on October 16, 2023. In review of the packet and supporting documents as well as the docket in the case, the court has concerns. The court lacks personal jurisdiction over so basically in this document, she's saying that the courts lack personal jurisdiction in accordance to Judge Michael Gordon's order. So you can see how they organized this, okay? You can see how they organized it. It's a 2-year-old could have seen this, okay? They're not too smart, okay? So she's referencing his order that is... She's referencing his order that is right here. She's referencing the order that's right here. And in this order, he's basically, coming up with all of this different stuff to try to support the fact that they're trying to creatively deny me justice in these courts with this. But what they just did, they just got themselves in big trouble, because the lid just got busted off of this in that motion. I'm not going to read all this because this video is getting long, but if you want to, you can read through this. You can pause this video and you can read this stuff. You can read this order, which is all null and void. All this is null and void. All this is fraud upon the court. These people, they're going to jail. They're going to go to jail. They're going to go to jail. If they knew what I knew, and they knew how I knew, they wouldn't be doing this. But, it's all said and done. Now, let's go to the juicy part, okay? Remember this new evidence I said we found? We found new evidence that these people been sued before. This ain't their first time. This what they been doing. So we gonna look at this. This is the new evidence right here. Let's look at this. Okay, this changes the whole landscape of everything. You see this? This was filed by a class action lawsuit. This was filed by a class action lawsuit by a member of class of parties who consisted of lottery players nationwide, all over the nation. They sued them for these rigged drawings. Look at this. Okay, this was filed January 3rd, 2017 in Iowa. Okay, so this was filed by a law firm representing somebody by the name of Dale Kohler. Okay, and it talks about all these rigged games. It talks about how they use these random number generators called RNGs and was just doing a whole bunch of fraud, just doing it, and they still doing it. Okay, and see, I didn't want to have to put their business out there like that, but they abused me in these courts, and they did this, so they made me do this. So when I found this, I said, "Oh yeah, they ass is out." But I didn't even need this because our investigation already told us all this stuff is going on, and it's still going on today. Okay, so look at this. Plaintiff Color brings this class action for damages sustained as a result of rigged lottery drawings resulting from Muscle's operations from at least 2005 until 2013. Muscle is owned and operated by agreement of its 48 members now, but at that time 37 member state lottery departments. Okay? So I'm not going to read through all this. So this is basically evidence saying that they lotteries was rigged, and you guys can stop this and read this. You can pause the videos and read this. I'll let you be able to pause and read it. Okay, so they basically tried to make me out like I was a crazy person making this stuff up, and now look at all this detail. And these people won this case. These people, they won. Okay, because this is what they was doing, and they figure it's too profitable to stop, so they rearranged their way of doing it, and they kept doing it. Okay, and they got caught again. I caught their ass. Okay, so here's all the evidence to show. Okay, so you can slow the video down or pause it, and you can read all this shit, get all this tea. They had a count of negligence against them, the multi-state lottery. They had a count of consumer fraud. They had a count of unjust enrichment. They had a count of intentional interference with a contract. They had a count of intentional interference with prospective business expectation. They had a count of fraud and breach of contract. Okay, and it was filed by these lawyers. Okay, Crawford and Morrow Law Firm in Iowa. Okay, now, okay, so that's that. We're done with this part. We're done. Okay, so we looked at that. All constitutional rights invoked, now waived. Now we're going to talk about a different court case. We're going to talk about my court case that I have in the United States Court of Appeals for the Federal Circuit, okay? Now, in this court case, this document was filed by their attorney, Matney Elizabeth Roth, okay, who represents the United States Department of Justice, all right? She represents the United States. Now, in this motion, she asked for an extension of time. She asked for an extension of time to serve her response to my brief. Now, I turned in a brief last month in October, and she had all that time to have her brief ready to be turned in, and she don't have it. Okay, she don't have it. And the reason why she don't have it is because what we cited in our brief is Marbury versus Madison. And you're not going to be able to get past that because it's standing on the Constitution, and there's nothing that Congress can make to go against the Constitution. It just can't, because the Constitution of the United States, for everybody listening, it's the mother. Okay, the Constitution of the United States of America is the mother of all laws, of every last law. So every last law has to be in compliance with that if that Constitution is invoked. So let me give you an example before we talk about this document. Let me give you an example. Say, for instance, you have a mother. Okay, let's say the Constitution is the mother. So the Constitution is the mother, and let's say the mother has to work, so the mother is going to be away at work, away from the house. So since the mother is going to be away from the house and at work, she needs a babysitter, okay? So let's say the state is the babysitter, state law is the babysitter. Um, for this example, okay? Now the babysitter would have to watch the baby. Now let's say for this example, the baby is just a citizen of the state, a person that lives in the state. Okay, they're the baby. Okay, so the mother's saying, okay, watch my baby while I'm at work and take care of the baby, and these are the rules that you need to follow. Okay, the baby need to be in bed before 8 o'clock. The baby need to be sleep and in bed before 8 o'clock and fed and everything. So the mother lays down her rules, okay? And then the baby, well, let's just pretend like it's not a baby, it's a young child. So we're still gonna say the baby though. So the baby is gonna also have rules that the babysitter is going to say. Like the babysitter might say, okay, you have to be in the house by you by 3 o'clock you have to be inside. You can't play with your friends. You have to be inside the house by 3 o'clock. Okay, you can't play with your friends after 3. You got to be in so you can eat and and get ready for bed and all of that stuff. Okay, so the mother laid down the rules and the babysitter laid down their rules. Now, the babysitter cannot make rules against the rules that the mother laid down. So the babysitter can't say, oh, the mother said that you have to be in the bed by 8 o'clock, but the mother is not going to be here until midnight. So I'm just going to let you stay up until 11 o'clock right before the mother get here, and then I'm going to put you in the bed because that's just what I'm going to do. Okay, but that's not what the mother asked her to do. Okay, so the rules from the mother is primary. Okay, so the babysitter can make rules and can deviate around those rules, but they have to be within the parameters of with the mother laid down. Otherwise, the baby, the child, we're going to say it's a young child, but we're going to call it the baby can say, Mom, the babysitter kept me up until 11 o'clock, and I wanted to go to bed, but they wouldn't let me. They kept me up until 11 o'clock. So now the mother is going to go to the babysitter, and the mother is going to ask the babysitter, did you keep the baby up until 11 o'clock? And then the babysitter is going to have to explain to the mother why, and it's going to have to make sense within those rules. So the babysitter is not going to be able to say nothing, okay, that is going to satisfy the fact that she went against those rules laid down by the mother. Now, if the baby don't go back and tell the mother, then the mother won't know. So that's the same thing as invoking the Constitution. When you invoke the Constitution, you're basically saying, I'm telling Mom, I'm going to tell my mom. I'm going to tell my mom. And if they say, well, we don't care, the mother is the same person who's paying the babysitter. Okay, you see how that works? The mother is the same person who's paying the babysitter and allowing the babysitter to make a living so the babysitter can pay their bills, but then they're turning around and saying that they don't care what the mother say, or for example, saying that or having an attitude like that. Then the mother is going to do what? Replace the babysitter. Okay, so the mother is the Constitution of the United States, and this is why anybody in a position of public duty or power or authority, they have to have a contract with that Constitution, which is that mother. They have to have the contract with the mother saying, your rules is going to be primary. I'm going to follow your rules. I'm going to do my job, but I'm going to execute my duties and my job with your rules in mind. Now, if someone comes before the babysitter and says, and they don't say nothing about the rules, and the babysitter start deviating and doing what they want to do, if that person don't invoke those mother's rules, then the babysitter is not placed on notice that 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 they're exercising and saying, oh, I want you to go by my mother's rules. But when you invoke that Constitution and they decide that they don't want to go with that, then they're saying, fuck the mother. And even though they have that contract with the mother, they're still saying, fuck that bitch. You see what I'm saying? That's what they're doing. So when they do that, guess what that is? That's treason. Okay, that's exactly what that is, because Congress don't have the authority to pass rules or laws that trump constitutional rights, because constitutional rights are the same thing as inalienable rights. Okay, and for those who have Black Laws Dictionary, you can look up inalienable. Okay, inalienable cannot be transferred, taken away without the consent of the person who has the right, which means that they have to give that right up by waiver, by not placing a person on notice that they're using the right. So when I say all constitutional rights invoked and waived, guess what? That's placing you on notice that there is no waiver of no rights, so you don't have no authority to trample on these inalienable rights. Okay, now if I didn't invoke that Constitution, then you could still, you can deviate a little bit, but when I invoke that Constitution, it stops there. You don't get to say, well, this and this and this and this. You in violation. You in violation of Title 18 USC 241 and 242. Now let's get back into this. This document here is the United States asking for an extension, and I said no, because you don't get to wait until the day of that your brief is due. Your brief is due November 27th. Okay, you don't get to wait until the day of and file a motion for an extension in lieu of filing a brief, because that's abusive to me, because you didn't give me no advance notice that you was getting an extension. You didn't give me no advance notice. I was expecting for your brief to be filed so I can go ahead and file mine, in this short time later after you filed yours, so the situation can be briefed and go before the panel. But you're abusing the process and you're doing this, okay? And I told her no. I said, no, I don't want you to get the extension. So I'm not going to read this. This is the motion that she asked for an extension with the federal court. And I said, no. I said, no. I said, no. And I also told her that, I said, no. I said, no. Okay. So this is her motion asking for the extension. And I'm going to show you guys my motion where I said no. Okay, so this is my motion where I said I don't want her to get an extension. Okay, I said no to the United States. You don't get no extension. Okay, you don't get no extension. I said no. Okay. Okay. You see this exhibit down here, Exhibit Luna? This exhibit sets forth that motions to extend time to file a document should be received by the court at least 7 days before the deadline for filing the document. FCR 26A2 for the timeline, okay? And so this is FCR 26B1 right here. Okay, so this is the rule that she's not in compliant with, and that is the primary reason why I said no, you don't get an extension, because you didn't notify me, you didn't tell me. So no, you don't get it. You don't wait until the day of. You can't do what you want to do. You're trying to contravene the heart of these rules. Now, if you would have told me last week or something, then, maybe that would have been different. But I still would have probably said no, because it's outside of the time of the rules. Okay? Because y'all going to hold me to the rules, so I'm holding you to the fire. Okay.
Can't nobody stop what God has blessed. Do you hear me? Think about it. They can't curse what God has blessed. They don't understand that. Y'all already know, just like with David. Remember David? See, they thought that David was not blessed. He was not chosen. He was not the king. They thought that. But baby, God said different. When Samuel came in there looking at them folks, he was like, this ain't it. But these all your boys? These all of them? It gotta be another one. And they thought that it certainly couldn't be David because he was out there. He ain't looked the part. He ain't looked the part. He hadn't been doing the type of work that the other people had been doing. They were soldiers, but see, David was not there doing like them. David a soldier too, because he out there throwing it up. Throwing it up with the lions and the bears and stuff back there with a little rock. Do you hear me? But see, that's what it was. God uses those that don't look like they supposed to be used. David slayed his tens of thousands. Y'all didn't even know that. And even after that, even after he was called, and even after the people saw exactly who he was, he was still chasing by his enemies. That was that's the sad part, but that's the crazy part. But think about your life. You keep thinking like, why your enemies keep coming at you? Why they keep trying to attack you at the job? Baby, after David got called and people knew who he was because he was slaying them tens of thousands, they ran him down. But God kept him. God was always there with him. God protected him. God even sent Jonathan for him. See, that's why I keep telling y'all, God is calling the unqualified. See, in the world, you are unqualified, but in God's world, baby, you already know. You it. Okay? You the it. Period. He's trying to show you that you ain't gotta look the part, you ain't gotta be the part, you ain't have to go to school, you ain't have to do everything everybody else is doing. Whatever it is, ain't nothing wrong with going to school, okay? Don't come for me, okay? I'm just saying there's a lot of people that go to school and they have to qualify for a job. They have to get a bachelor's or something like that. But see, I'm just saying there's just a living example that with God, he can put you in the forefront. He said, I will make you the head and not the tail.
Okay.
Above and not beneath. See,
Okay.
he said the first shall be last and the last shall be first. Listen.
Tell him, baby.
It's different when it comes to him. It's different when it comes to the kingdom of God. It ain't
Tell him
nothing
about
like
me,
the
baby.
world itself.
Tell him about me.
It's different. See, that's why they want to make it look like that, to discourage you from living out your purpose, saying, oh, I can't do this because, listen, I don't qualify. But see, that's how Moses was. See, Moses felt like he couldn't do it because he felt like he was unqualified. That's why God sent Aaron for him. God sent Aaron to Moses to help him. See, Moses felt like he had a stutter. He couldn't do what he was supposed to do because, that's what the world said. The world, Pharaoh and them, they was like, no, boo-boo, no, you can't do all that. You can't, you over there on that side. You can't do it. But with you, it's just like that. You might not qualify, but with you, it's just like that.
Tell him
you
about
might
me.
not qualify in that position, but God is gonna call the unqualified. Amen. Praise the Lord.
So, I'm just going to freestyle a little bit just before we come to the end of this video. I just wanted to say, it was very important that we took some time away. We've been very busy working on a lot of different things. We have a lot of exciting things coming up. But we wanted to kind of take a break away from the internet for a minute on Deception Stoppers channel. We wanted to take some time away, and while we took some time away, we had some things happen that was pretty disturbing. We had our channel hacked, and we had my phone hacked, and we had all kind of different stuff happening and taking place to sabotage these proceedings. We had obstruction of justice. We had our mail sabotaged. We had the certified mail sabotage. It was just crazy, so we took a step back, and it just was a lot. It was a lot, but we know that justice is prevailing in the matter, and it was just a lot that happened that we needed to let some time go by. And it was shortly before this was just a few days ago when our accounts was hacked, and that we had a disturbing message that was put on our community post, and many of you probably seen it, but we had it rectified and we couldn't get to it immediately, so it was up for a while before we was able to take it down. But yeah, we just want our audience to know that it was very important for us to take some time away, and it was very important for us to get all these matters dealt with and get all this stuff buttoned up. So there it is. We're not gonna hold you any longer, but that's the video. All constitutional rights invoked, none waived, to my beautiful and brave. All right, happy holidays to everyone.
There is no one like you. There has never been anyone like you. There shall never be anyone like you. Therefore, know yourself. Be yourself. Authenticity is everything.
You scare people more than you can imagine, and what terrifies them the most about you is the things that they cannot figure out, the puzzle pieces, the uncertainty, the paranormal activities that could happen to them when they are around you. You have this presence, this power, this energy about you. Yes, you may be one person, but you're not just one person. You are an individual that's surrounded by an army. If you look behind this bird, I think that's a crow. There's celestial beings, an infinite amount of celestial beings behind this crow, and this is what helps you be the celestial gatekeeper. Not only do you have permanent information, important information about this planet, this universe, how everything works, but you do have a specific energy signature where you can even control time. It's almost like time is repeating itself, or you go through these periods of deja vu. You have this presence or this energy that's similar to an archon, and everything that you do creates a ripple effect within the universe, especially when you are in a meditative state. You may not even come from this planet. You could be from Planet X, Nibiru, Planet 9, Andromeda, Sirius, a series of constellations, but you descended on this planet in order to help Earth grow. And the more that you become whole within yourself, the more you learn about your inner power, the more things that you can unlock. Timing is critical. I feel like time tends to be things that can work against you even, but you are somebody who is an Earth guardian. If you look at this being, he has white wings, so you give off energy of light worker, somebody that's here to help human beings ascend, and the best thing that you can do is try to stay grounded and rooted, especially in times of chaos. What scares people the most about you is the fact that you receive information from other dimensions, other realms, other time periods about things that you wouldn't know of other people. It's like you can see people's secrets, you can see their deepest, darkest things that they have in Pandora's box, the things that they keep closed in their closet. This is what terrifies people the most about you, is that you can see through them, you can see through illusions, you can see when they're trying to put you in traps. And you also could have this precognition type of energy where certain things that you tell people will happen does happen. At first they doubt you, and then a couple of months, maybe even years down the line, everything that you said would plays out to the T. And so you're somebody that also listens to your ancestors and guides, and you may be an old energy, as old as Sun God Ra. And with High Priestess, there's something about you having roots that's tied to the Egyptians, and the Egyptians also had connections to the Anunnaki, the Sumerians. So your energy, it's you were here from the beginning of time. Something about you is biblical. The type of purpose that you have is biblical. You're here to change the energy signature of the planet, maybe even help create a new Earth. And I feel like when you write, at times that tends to be your strong suit. Things that you write, you are more likely to even accomplish. And I feel like some of the things that you write even come to fruition. So writing is a skill set that could help you. You are somebody that's extremely strong, resilient, and you don't have the same amount of protection as everyone else. Your protection is amplified because you have this purpose that's going to help everyone else succeed and grow. So anything of lesser value that tries to attack you will have no problem having it being removed. That's why it's important for people not to play games with you, because the type of karma that they can get could even result in their death, especially if those are the type of things that they're trying to send your way. With the Four of Swords, the time that people are afraid of you the most is when they're asleep, when their defenses are down, or when they're astral traveling, because I feel like that's when they can really see what your true presence is, but they don't necessarily know how to decipher the messages or even make sense of what they see. But when people have their defenses down, that's when they can really feel how prominent you are. And what's also scary about you is just like how you can pull people's swords and heartbreaks out of their heart. You also have this double-edged sword about you where you can cause and create just as much destruction, pain, sorrow, grief as you can heal. And so this is what is also dangerous about you, is the fact that depending on how someone treats you will determine the side of you that they get. And you have this very destructive energy about you, and it's not necessarily in a negative way, where you have the ability to change paradigms, to even bring down systems. For example, you get arrested, you file a lawsuit against a specific department and that whole department crumbles down. You have this kind of energy of a true speaker, whistleblower, someone who can change the regime of certain systems because of the level of protection that you have and the amount of influence that you have worldwide. If you have a specific skill set, if you were to share that with other people, it would be something that would help you become world renowned, or it would be a skill set that would be acknowledged or admired from people far and even close. With the Ten of Pentacles, what scares people about you also is that they know that they're only seeing a small portion or piece of how much you are truly capable of. And I feel like you're not even tapped in 100% to your inner power. It's probably about 20 to 30%. So there's so much of you that you have yet to discover. But in order for you to go through this discovery, you also do have to meet snakes, people in your circle that will try to bring you down. You're meant to be an authority figure, not just in the 5D, where spiritually you have all this knowledge, wisdom, and power, but also in the earthly realm of the 3D. And this is why people get so off-put by you. Something about your energy just irritates people. People don't like you for no reason. Just your presence alone bothers them. And it's because you carry that authority in this lifetime as well. You scare.
Yeah, I bet there's no way there's nothing.
Jacksonville man just won $1 million jackpot from a scratch-off, where he bought the winning.
To you, Jim. And I'm Shonda. And you're watching Lotteries. The first ball up is 3. The next is Meatball. The next is Meatball. And the last is Bread. Making tonight's lucky numbers 3, Meatball, Meatball, Bread. Back to you, Jim.
Thank you to divine. Thank you to the divine.
We gonna break down they shit.
Any final words for the people?
Au revoir.
See, as you can see, the more you fuck around, the more you're gonna find out.